clerk will read out the names and tonight you will watch. It is a beautiful time on television, and you're welcome to our program on TV, Parliament and Governance. My name is Evan Sunokoge. Well, you do know, as always, that the program subjects on issues at the Nigerian legislature, and of course, as it relates to daily governance, you may want to say. Well, today on the program, Parliament and Governance, we are going to be looking at the Nigeria's 2023 election as it relates to the legislature. And of course, if you have to rephrase that, you may want to say that we're talking about the National Assembly election. Well, as we speak now, we understand that the umpire, that's the Independent National Electoral Commission, has set the dates. As we speak, we understand that on the 25th of February 2023, in all the 109 senatorial districts, we're told that voters are going to be voting their various senators alongside with their various National Assembly members, talking about the House of Reps and all that. Well, one thing that seems to be very glaring is the very controversial nature as it relates to who is really going to be the candidates of some political parties as we talk about the National Assembly election. Well, we understand that some political parties are still branding, or some candidates will say, still go with the name candidates hopeful. What does this portend for the National Assembly election come next year? Well, to look at all these issues with us this day, we're so privileged to have Neville Obakedo. He's a public affairs analyst and also a political discussant. He's a lecturer with the Department of Post Science at the University of Benin here in Benin State. Mr. Neville, you're welcome to the program Parliament and Governance.
ITV, thank you for having me in this your wonderful program, Parliament and Governance.
Okay. All right, so as we just tried to say that come February, 25th of February 2023, we're going to be having elections into the 109 senatorial seats alongside the various federal House of Assembly and all that. Now, you have political parties, you have candidates still going by, you hear them hopeful. Candidates vying for a political, vying for a seat at the federal seat, and he goes by the name hopeful. Now, I don't know, what does this portend for as we await for the election?
In the first instance, the Nigeria political process, i.e. the electoral process, is a product of law and is guided by an act of parliament. In this case, the Electoral Act 2020. And the Electoral Act makes provision for political parties to organize primaries and to elect from those primaries those that will be the flag bearers of their political parties. Now, the crafters of the law, they are aware that there is the tendency that there will be some actors in that political process of the political party that will want to have their way against the law, against the provisions of their constitution, and against the provision of the Electoral Act. That is why in the process of making the rule, they make provision for application of the rule and adjudication of the rule in case there is an infringement of the law. So because of the kind of godfatherist politics that we play in Nigeria and elsewhere in the world, there is the tendency, usual tendency for some people to want to circumvent the process. They want to hijack the process. They want to make sure that a particular candidate that may not be wanted by the delegates, he will be the person to carry the flag of the party. This is responsible for the crisis that led to the use of the word hopeful hopeful, maybe hopeful because there are crises in court over the matter, or maybe hopeful because they are competing with another political party in that election, or other political parties in the election, and they have the hope that their candidate may carry the day. So you can look at the word hopeful from two perspectives. One perspective, because of the crisis that led to a petty case in court or petty cases in court in particular senatorial district to federal constituency. Hopeful because the particular political party sees their candidate as the candidate that is likely to win. They have the hope, and they have the beacon of hope on that candidate. That is my initial reaction. But we need to understand that the process of leading a nation and the process of recruitment into the leadership cadre of a nation, whether the presidency, president and vice president contesting election, whether the National Assembly, those that are going to the two chambers of the House of the National Assembly, House of Senate and House of Representatives, there must be a deliberate process by the political actors, those that cause the church, to ensure that they build bridges in their party. If they have any political party, the big wigs in the political party, if they have in their political party a certain candidate they have in mind who may not be popular but is acceptable to a clique, the iron law of oligarchy of the party.
So the wheels, so there are wheels and capacity.
Yes, they should talk to those that are popular and are likely to be acceptable, so that they can be, through their give and take, they can determine who will carry the card of their party.
Okay.
As the case may be.
Now, we are talking about the 10th Assembly here. Next year's National Assembly is going to be the 10th Assembly. And by March, we are expected, it is expected that that Assembly would have been inaugurated. That's why we say that by February 25th, the elections are going to go on. But from the way things are now, do you see the possibility of having such an assembly inaugurated, having this kind of crisis here and there, candidates branding with the names hopeful and all that? Don't you think that we may even have staggered elections as it relates to the National Assembly election next year?
I fear very greatly as a human being. I fear greatly as a political scientist. And the tunes, sometimes macabre dance tunes that we see in our country, despite the fact that the Electoral Act 2020 has made provisions for punishment for individuals and groups and political parties that may perpetrate violence and crime that disregard the Electoral Act. But if you look at what is happening from various parts of the country, they try to create the impression that the way we are going, this republic, the start Fourth Republic, may go the way of previous republic, unloved and unmourned by the bedside. That's why I use the word I fear. But if the political actors, those that want their people to go to the National Assembly as a case study, if they are interested in the electoral process of this country, they should ensure that the needful is done, so that the National Assembly be inaugurated if elections are conducted in Nigeria. So that we can have our
elections first before the inauguration.
Yes. Yeah. Talking about election, the other day I'm in a group, I think a group of my colleagues, and we're discussing some of the things that were happening in Nigeria. And I made a statement. I said, from the way things are going, and because from what has happened before historically, if you see as a researcher and a political scientist, you see the same tendency coming up. You can extrapolate, you can predict, to say that based on what has happened before, this is what is likely going to happen. You may not be exact, you may not be correct, but there will be an element of truth in it. So that fear that this democratic process may not be properly vetted is there. But if those who are actors who have been benefiting from the system, who knows they are likely to benefit in the next dispensation, if they play the politics as a do or die politics, the consequences of their action may affect the entire process. And you know, the other day in 2015 or so, the then National Security Advisor to the President, after holding meetings with series of security officers across the country, made a statement, and the statement was that election be postponed, and the election was actually shifted, even though it was still within the provisions of the law. But if we run into a crisis of shifting an election that violates the Electoral Act, it will be an invitation for an illegitimate government to come in.
All right, so with all this build up now to the 2023 National Assembly election, what do you think would be the best approach in solving some of the emanating issues? Because it is not just, I don't want to make recourse to maybe some of the candidates in those states. We have, other states that, we have candidates also that are also having the same issues. So what best method can we approach now? Do we use a political, method of resolving the issue, or let's go back to the law and find out what the law says, in resolving some of these impending problems?
As a political scientist with interest in conflict management, for conflict resolution, or peace and conflict studies, no matter how strong you think you may be in the field of conflict, maybe you are a warrior, you have been fighting, you have been winning. A time may come that you may not win, and that defeat may surprise you and may have a monumental impact on you as a person. So that's why sometimes when we are involved in trying to settle people or groups, we say that we should adopt what we call the alternative dispute resolution, that will not make you to go to court of law and insist that you will resolve your matter through the court of law. Talking about alternative dispute resolution, political parties, they are parties that are supposed to be of men of the same like minds, even though they may have differences in ideology, whose main aim is to capture and run the machinery of government. If I want us to capture and run the machinery of government, and there is a dispute between me and you and others that will not make us to win the machinery of government and run the government because of my own interest, I would like a situation where we cannot come to a round table and resolve our problem in the interest of our general interest. So I use this opportunity to call on political leaders that their parties are ravaged with crisis, whether APC, whether PDP, whether a Labour Party. They should go back to the Constitution and use the conflict resolution mechanisms in their Constitution.
In the party's
Yes, in the party Constitution, to resolve their crisis. Now, there are some who go to court without even following the processes that are supposed to be followed within the party. They will just go to court. They go to court, for instance, because they feel that they will not get judgment they will not get fair hearing within their political party structure. They go to court. And the court will now say the Constitution you did not follow the procedure of the Constitution before coming to court. And so on. So, in the interest of the party and in the interest of our nation, such political parties that are having crisis right now should look inward and put the set machinery in motion to resolve their conflict internally, because the major election where they are going to compete with others is more important than the one than their in-house fighting.
Okay. All right, viewers out there, the program is Parliament and Governance on independent television. And of course, we are looking at the Nigeria's, talking about the 2023 National Assembly that seems to be riddled with crisis here and there, talking about who becomes the candidates of XY party and all that. Now, we have to pull this topic together today because of some of the candidates that are going by the name, by going by the word hopeful. You hear a candidate says that is a hopeful candidate in that election. So it becomes very, very contradictory. You are a candidate and yet you are hopeful. I don't know how to put it now. Now, Nevi Bakedo, you talked about, for political parties going back to their constitution in one way that they can resolve some of the issues. Now, this brings us to want to ask the question, because some analysts are also looking at it differently. That perhaps the party's constitution may not be enough to resolve some of the issues now, that it has to be the constitution of the Federal Republic of Nigeria. Take, for example, a clear incident whereby the party says that, let's even go back to the primaries, so to how the issue started, that INEC is supposed to monitor a primary, or the National Working Committee is supposed to send officials to a primary and all that. Now, some analysts say that even if you try to use the constitution of these parties to resolve some of the issues, at the end of the day, questions will still be asked on what the constitution of the Federal Republic of Nigeria says as it relates to the issue. Then the question is, which of the constitution now do we now resolve to at the end of the day? Is it the party's constitution, what the party says concerning X, Y, Z matter, or what the constitution of the Federal Republic of Nigeria says concerning X, Y, Z matter?
The Constitution of the Federal Republic of Nigeria, 1999, as amended, is the ground norm of Nigeria and is the alter origo of Nigeria. That's the action of every citizen of this country, whether elected, whether appointed, whether ordinary citizen. They are derived and bettered on the Constitution. And so any other document that guides the conduct of human beings in places of work, in political parties, in various organizations, any of their provision that is inconsistent with the provisions of the Constitution, there is the provision of the law. That provision, that action is null and void from the beginning. Is because of its inconsistency with the provisions of the Constitution. Now, I will give you an instance so that you will understand. The other day, some persons went to court in their place of work. Their memorandum of appointment and agreement, as they were offered appointment, states that anytime you want to take any legal action against this organization, you need to give them 1 month notice. It was an agreement signed by both the people that offered. Yes. Now, if you now have a case that violates your fundamental human right in that place of work, you cannot just run to court if you know that that problem emanated from that place of work and it affects you, it infringes on your right. It is for you to take your pen or ask your legal representative
to write
to that organization to say that your right have been infringed upon this way, that way, and that you are giving 1 month notice to the organization for them to address the issue.
Go to court.
Yes, if they fail to address the issue within 1 month,
you will go to court.
You will not proceed to court.
Yeah.
You ensure that that document is received. Ensure that it is received, because the document can be received and the people that are dealing with you can just say the document was never received. How are you going to ensure that the document was received? When you are going to submit it, you make it 2 copies, you give them 1, they sign 1 for you. Ensure that they sign it and put a stamp on it.
As received.
Yes. So that when you now proceed to court, somebody will not go and accuse you of forgery or go and accuse you of lying on oath, as the case may be. Now, if you proceed to court without going back to provisions of that memorandum of agreement and understanding between you and your employer, the court will dismiss your case, because the lawyer from the other side will come to court and say that the court lacks jurisdiction to entertain this case. Why is the court lacking jurisdiction? Because a jurisdiction, they will not define jurisdiction.
Because there's no agreement.
Yes, and they will not say, based on the agreement of this court is not in a position to entertain this because this person did not give the prior notice of 30 days.
So the analogy now, how does it relate to this issue?
How the analogy relates to this issue is this. If you, as a member of a political party, whether you were an aspirant
or a candidate.
or a candidate,
Yeah.
and you are bounded by the provisions of the Constitution, as a matter of fact, of that political party, it is the Constitution that makes you a member of the political party. And so if you want to take any action against the political party, you have to notify the political party. Notify the political party. First of all, leave the issue of whether you are going to get justice or not. First of all, let the political party know that you have been victimized.
But how does that become possible? When you have, take for example, with what is happening in some states, let's say in the People's Democratic Party in some states now,
Yes.
where you almost have a polarized interest in just one single political party. So how do we achieve that?
If we have a polarized political party, that's the case of PDP that you mentioned, you have various factions. The first thing that you have to know before you do anything with the name of PDP is to find out from INEC and the courts which of this group is the legal group.
Is it INEC that says which group is the legal?
When I say INEC,
because INEC does not have anything to say about.
yes. When I say INEC just now,
yeah,
and I use the word legal, and I'm trying to marry the two of them. If there's an order from court that says this person is the candidate of this party, and we have factions, we have 3 factions of the party, and INEC is served the document, and INEC was joined as a party and served the document, INEC is, the onus is on INEC to obey the court order, irrespective of the factions, irrespective of the fact that there will be other candidates from the other groups that will be parading themselves as candidates that were elected through the primaries process. So that's why I use the word, I had to include INEC just now. It is when the Supreme Court, which is the final arbiter, has ruled, and INEC will still be served the judgment, that INEC's hands will not be tied to not accept the final judgment of the Supreme Court.
Okay.
In determining the candidate of the party at that point, irrespective of the crisis in the party.
All right, now that we are talking about the Supreme Court now, the big question that we ask is, do we have the time? Because we are looking at an election that is time-bound. Just like what we said, that by 25th of February, the National Assembly election would have been held. And by March that same year, we would have had an inaugurated 10th Assembly. So putting all this together, do we have the time? Because from the look of things now that we are saying that some of the candidates are hopeful in next year's election, it then probably means that some of these cases may even proceed to the apex court. So do we have the time in all of this?
You see, the beauty of the court is that when the court pronounces judgment, even after election, it is an attempt to right the wrongs. Let's talk about next year, 25th of February 2020.
Next year, yeah.
There will be an election, National Assembly election, across the 109
senatorial
districts,
yeah,
and across the 360
federal
constituencies. Now, since the election has not been conducted, any matter that is happening now in the political parties is a pre-election matter. It's pre-election, and the law is clear that pre-election matters are not reserved for the tribunal; they are reserved for the Federal High Court. And I listened to the Chief Judge of the Federal High Court of Nigeria the other day, when he gave a marching order to all the judges that are handling pre-election matters in Nigeria, that they have 4 weeks to conclude their cases. He has said that about 2 or 3 weeks now.
They have 4 weeks.
Yes. So if he has said that, by implication, the Chief Judge of the Federal High Court is saying that they have 4 weeks of accelerated hearing.
Yes.
Yes, to hear those cases.
Yeah, yeah.
Yes. And I know that when such cases also get to the Court of Appeal, they are going to be given accelerated hearing, so that the political parties will know who their candidates are before the election. So that is the position of the law, and we hope that the existential and the experiential frustrations in our system that are also applicable to the judiciary will not affect this decision by the Federal High Court and by extension by other courts of competent jurisdiction that are to ensure that the right thing is done before election.
Anyway, this is where we end the show today because the issues are still emanating. Just like what Neville Obakedo said, that the Federal High Court has just about 4 weeks to ensure that all existing litigation we end within the 4 weeks. And of course, when you put that together now, we've done like 3 weeks, so we have just
1 week.
So, so it goes to show that in this time, some of these issues as it relates to the National Assembly election for next year is going to put to rest, so that the candidates, so that we won't be having candidates that are hopeful, because to me it's more or less like a contradictory situation now. You are a candidate and you go by the name hopeful. I mean, what is it? So, and also too, so that the electorate will get to know who the candidates are, so that they can actually prepare on how to cast their votes. We want to say a very big thank you to Neville Obakedo for joining us on the show today, Parliament and Governance.
Thank you for having me.
Independent television. Well, this is how we end today's edition, edition on the show, Parliament and Governance. My name is Evan Sunokoge. Goodbye and God bless you.